Good afternoon. First, let me invoke Chatham House rules. I don't know that any speaker has done that, but some of us, not me, do not want their words taken out of the room and used in any type of proceeding against them. Why don't I start by having each of the panelists introduce themselves, and with an emphasis on how the topic is in their practice today. Anya.
Hello everyone, my name's Anya Proops. I'm a barrister, King's Counsel, specialising in data, tech and media. My practice really falls into two parts. On the one hand, I do a very significant number of data privacy class actions. And on the other, I'm very heavily involved in data regulation, most obviously in the context of disputes with the ICO. I typically, though not invariably, act for the controller. I've got a number of quite hot live matters at the moment, which is in part why we're looking to invoke Chatham House rules.
Very good. Ryan.
Good afternoon, everyone. I'm Ryan Clarkson. I'm the founder and managing partner of Clarkson Law Firm. We are a 25-lawyer public interest law firm headquartered in Malibu, California. We prosecute in state and federal courts across the country, primarily in California and New York. We focus our work on about a dozen practice areas, including privacy and data breach, misuse, data misuse. We do environmental class actions. We do employment class actions, competition cases, consumer class actions. We have an active mass arbitration portfolio that is run by my partner who's here in attendance, Yana Hart. And we have a very active appeals and writs division, which is managed by my partner, Glenn Danis, who is on an unprecedented hot streak of 8 appellate reversals in a row. It's wonderful to be here in London. Thank you to the Global Legal Group for the invitation. And it's nice to be with my friend and a true giant in the plaintiff's bar in the United States, a consumer champion and a privacy champion, John Yanchunis. Thank you.
It's very nice of you, Ryan. My name is John Yanchunis. I'm with the firm of Morgan & Morgan. I run the class action practice. For those of you in the UK and EU, if you've been to the United States, it'd be hard to miss an advertisement of my law firm, whether it be John Morgan shirtless on a billboard in Florida or wearing a Red Sox uniform in the city of Boston. And my practice focuses mainly on data privacy, and it, to me, is one of the most important aspects affecting humans. When you think about, for me at least, what are the most important issues facing human kind in this world? Environmental challenges, climate change, however you want to describe it. Human rights violations, the division that we see both within the United States and other countries, as well as the conflicts around the world. The other one is data privacy. And we're going to try to squeeze in 2 or 3 days of material into a very short period of time, kind of hitting some of the highlights. And certainly one of the issues that I think the last panel kind of touched upon, but not in the way we're going to, is to talk about artificial intelligence. And Anya, let me first turn to you and talk to you about how the regulatory regime is addressing that in the UK.
To which I'd say, what regulatory regime? Because at the moment, I mean, subject potentially to data protection legislation being used as a way to get into the issue of the appropriate use of AI, we don't have within the UK a regulatory regime that is specifically aimed at curtailing, controlling the use of AI by big tech or indeed by anyone else. That's, of course, something that's been very recently debated by the Prime Minister with Elon Musk and various others at Bletchley Park over the last week or so. And it looks like, we are trying to orient ourselves towards creating such a regime. Of course, there are really fundamental issues about how you construct a regime in respect of AI, when none of us are altogether sure what the dangers are and how far the dangers go, and how you achieve effective regulation in a way that addresses the potentially harmful aspects of AI without undermining the potential benefits and boons that it can bring to humanity. So we're really at the foothills of working out, what the underlying kind of ethical principles are before we even get to kind of the strict legal analysis in terms of how we want to regulate AI. And other jurisdictions are perhaps a bit ahead of the curve, but we are at the moment in the very early stages looking at how we want to shape this regime. And I should say that I think that inevitably, if we're looking at the situation from a global perspective, cultural norms are going to come into play. Cultural norms and socioeconomic pressures. For example, does the UK want to go in hard on AI on the basis that, well, if we do that, that might kind of undermine our economic position and our desire to attract big tech into this jurisdiction? Or do we want to think about the voters and say, yes, we are going to go in hard on AI because we really see there are significant risks for individuals within our society? So, I mean, these are the sorts of issues that our politicians are going to be debating.
So one of the things about big tech that I'm sure everybody knows, that it doesn't end with territorial boundaries. The way Google operates, Meta, Twitter, it's worldwide. The technology spreads beyond the US territorial borders to the EU, to the UK, to Asia, to Africa. And perhaps, and I've spoken about this before, the litigious nature of the American public. We happen to be at the cutting edge of some new litigation, and actually the gentleman to my left has been on the cutting edge of that, one of the first filed cases addressing the issue of of artificial intelligence. And Ryan, if you could speak to us about that.
Yeah, I'd be happy to. Like the UK and the EU, there really isn't much in the way of regulation of online harms like social media, like AI, which is a very new technology, really as of the start of this year. I mean, if you think about a year ago, what you were thinking about, AI probably wasn't even on your radar. Of course, it's rapidly entangling itself in every aspect of our lives today, and will continue to do so for the foreseeable future. So in the absence of regulation, then how do you hold big tech to account for creating wildly volatile technologies that are untested and, I would argue, contrary to my counterpart here, very dangerous with known risks right now in the short, medium, and long term? Well, Congress really in the United States is unable to pass laws that even most of the American public agree on. So it's unlikely that something like AI is going to be regulated by Congress, notwithstanding well-meaning senators and congresspeople with bills in committee. There's been some work done by the White House, and in particular, President Biden has recently issued an executive order which is very broad-based, but it instructs agencies to take action to address the harms while trying to encourage the positive outcomes that we all think can come from AI. And it encourages bipartisan legislation from Congress, but again, that doesn't feel like it's forthcoming. And so in this situation, we decided to take action on behalf of the American public and file a case against big AI for essentially stealing everyone's personal information in order to build large language models that even big tech admits they don't fully understand the risks of. It is a big swing, but we think it's important given the executive and legislative branches were not built to move as fast as this technology for the courts to weigh in. And that's the basis of our cases against OpenAI, Microsoft, and Google. But these big tech companies, I think, are just the tip of the iceberg. Every company is using some form of AI product, and I suspect that this is going to be an area ripe for litigation, both in the United States and globally going forward.
And in the litigation that you filed, what have been the major claims or theories of action that you've advanced?
Yeah, the claims really could be categorized into three buckets. There's a consumer protection claim, so there are consumer protection statutes that are passed by states. There are federal consumer protection statutes. There are traditional notions of property, right? And then there are privacy claims, and some of those are state claims. We have a California Constitution privacy claim. So those are the three buckets out of which they arise.
And then have you come up with theories of damages?
Yes. Now, I'm sure that this is going to be a hot topic as to how to quantify damages when it comes to the theft and commercial misappropriation of people's personal information. But we can look at this from kind of a couple perspectives. One is, our data is valuable. We know our data is valuable because there is a mature market for the purchase and exchange of data in the United States and around the world. Okay? And there is ethical and lawful sourcing of that data through the purchase of that information. So you could look at how it's valued from kind of a fair market perspective, but I would also look at it from the perspective of an unjust enrichment perspective. Since these AI products have been deployed around the world, OpenAI, we'll use OpenAI for example, its valuation has increased from something like $30 billion to over $100 billion, and it's rising dramatically with every passing day. Microsoft and Google have both added hundreds of billions of dollars to their market cap. Without our information, none of that would be possible. So I think that there is an angle to view damages from that perspective as well.
So there's a close analog in intellectual property litigation, copyright, patent infringement, and that is to look at not what the plaintiff, or in this case the consumer, lost, but what the defendant gained as a true measure of damages. So hopefully that will take root, and we've seen that in some data misuse cases. Let me turn to another topic that is, I would say, extremely harmful in the world today, and that is social media. Its addictive qualities and some of the ramifications. Anya, can you talk about that from the UK perspective?
So as many of you in the audience will know, here in the UK, we're kind of facing a new era in terms of working towards making the online environment safer for all users. And then we have a new Online Safety Act that's just been brought into effect by Parliament. I want to talk you through the dynamics of that legislation in a moment, but it is important to note that it is a really kind of key moment in the shift towards making online intermediaries, both platforms, social media providers, and search engines, responsible for creating a safer environment for online users. And in that sense, it's a really significant development. It might be useful if I just explain how the kind of online intermediary liability picture stands, if you ignore for one moment the Online Safety Act, what the picture looked like before that act came into effect. And the basic position was that online intermediaries didn't carry any liability for the content that they hosted or disseminated unless they were put on notice that particular content was unlawful because it was defamatory or it breached data privacy rights, and they then, having been put on notice, failed to act expeditiously to remove that content. So really quite a limited reactive liability that's only engaged in respect of specific unlawful content that's posted online. We're moving into a new era with the Online Safety Act because now the focus is not on that reactive responsibility to remove content that's unlawful once you're on notice of it, but instead we're moving now towards a proactive liability regime where the online intermediaries have duties of care aimed at ensuring that they put in place systems and processes to ensure that the risk that harmful content will be shared or disseminated is minimized. So first of all, what's distinctive about this regime is the proactive liabilities, responsibilities that they place on online intermediaries. The second important feature to note about this legislation is that whereas under the original e-commerce principles I was referring to earlier, the focus is very much on specific unlawful content. This is a regime that is aimed at safeguarding the online users, not only against content that is unlawful and harmful in that sense, but also, so far as children are concerned, protecting them against content which may be lawfully published on the internet, but is nonetheless harmful to their interests, for example, because it might encourage them to self-harm. So there's this new category of harmful activity that this legislation is preoccupied with, which is content that's lawful but awful so far as the children are concerned. But it's really important to understand that this is a regime that is aimed at getting online intermediaries to create these systemic safeguards for all users, but particularly for children. And it's also important to understand that the duties of care that are imposed on online intermediaries are under this legislation. The way that the legislation is designed is that those duties are not, on the face of things, enforceable by the individual users. They are instead enforceable by the UK media regulator, namely Ofcom. Ofcom has some pretty swinging powers under this legislation that include, not least, the power to impose penalties on errant online intermediaries that equate potentially up to 10% of their global turnover. So we're talking about potentially absolutely vast liabilities flowing from this regulatory regime. There's then a separate and pretty interesting question about whether the principles that we see emerging through this legislation, whether those principles could ultimately be deployed, not by Ofcom, but by individual users seeking damages or injunctions against the online intermediaries using the principles that have been established by the online safety regime. And you can bet your bottom dollar that we are going to see claimant firms seeking to use those principles to vivify the class action civil litigation market in due course.
So one of the biggest comparison contrasts between the UK, the EU, and the United States is we don't have a good regulatory regime to address a number of different issues, including this one. In fact, based upon the Constitution, although I've not read the legislative history, we have Section 220, which actually provides immunity to social media that host free speech. The problem is there's an inflection point, and that's when it causes damage. For the last 2 years, I've undertaken a study with the help of 2 ex-FBI agents who were in my law firm and a cybersecurity consultant to look at somewhat of the root cause or the cause and effect of the number of mass shootings we have in the United States. It is not easy, or it's not hard to find that most people who commit mass shootings are between 18 and 25. They're Caucasian and they're male. And what we have found in looking at social media is there are extensive artifacts posted by those individuals indicating with little prediction that they're going to engage in mass shootings. And we've undertaken this study on behalf of our government trying to figure out, at least a state, what can we do to stop that? Because we're not going to be able to take away anybody's guns. It's an important part of people's lives, some, not mine. I have no guns. The other type of social media harm, and it's based, and understand, I'll ask Anya and then Ryan to comment on this, is COVID and the way we were cloistered, segregated, caused people to use social media in large measure, including children who, at a very time in their life, very socially active, which helps in their maturity and their development, began to spend more time on Facebook, Twitter, TikTok, and there was a spike in the number of suicides among young girls and young men, boys, caused by, and I'm advocating as a plaintiff's lawyer, because one of my partners is the co-lead in a case against Meta pending before Judge Gonzalez-Rogers, that there's a causal connection between, and I know you'll disagree, and I respect that, between the addiction that comes with some social media use and these harms. I mean, causation is going to be an issue, obviously. But social media knows how much time Glenn Dennis spends looking at Facebook. Not only that, but what he looks at, how much time he spends. And then they send him content, I'm just picking on you, to entice him to remain on that social media platform. And you know, one of the things that I think about, because again, social media is destroying America. We're going to put it back together. But we have people on the left and the right, Republican, the Democrat, and then most everybody else is in the middle. But it's caused people to lose critical thinking and to be more influenced by what they see that somebody else that they don't even know post. But it's sent along to them by a friend, and therefore it has a level of credibility. And it's really destroying part of the American fabric of working together, and hopefully we'll be able to resolve that. So I think that's kind of a platform speech, and I apologize for that. But Ryan, let me turn to you and get your comments.
Well, I think we're experiencing this it is an epidemic of, among our children in America, our teenagers, even adults, of loneliness and depression and self-harm and suicide, because these technologies were designed to keep people's attention and designed to engage people. And we know that they're engaged by inflammatory materials, materials that result in body dysmorphia and loneliness and depression and all of these horrible things that are perhaps unintended consequences of the technology. I think, you know, we've had whistleblowers come forward from within these organizations who have talked about the way in which the technology was designed, the infinite scroll, for example, and other aspects that have resulted in all of this. And I think, you know, there's a nice tie-in here to what we're experiencing with AI, which is when we look over the past 2 decades of social media maturing and all of these kind of unintended consequences, we can't risk the same unintended consequences with AI. And so I think that is really what you're hearing across nonprofits, what you're hearing from regulators, politicians, even from the industry professionals themselves. They acknowledge that they need to be regulated. In fact, they're crying from the mountaintops to regulate themselves. But there's this tension that exists between delivering a return to corporate shareholders and doing what's right for people. Sometimes there's a tension that exists there, and when that tension occurs, it's often profits over people that results. And so I would say, you know, while there are concerns about, you know, potentially discouraging big tech from enjoying the markets in the UK and EU if we were to overregulate, I have a different philosophy on that, and I would posit that we have an opportunity to institute safety protocols and guardrails now that we can then use as a model for the rest of the world. And if we do it properly, I think we can get the rest of the world on board, China and other places included.
So, Anya, in terms of the regulatory scheme that you talked about here in the UK regarding the liability of social platforms, that would be liability in some way to the government, correct?
So it's a duty. The legislation imposes a series of duties of care enforceable by a domestic regulator, Ofcom, which are designed to make the online environment safer for all users, but particularly for children. You gave the example of the risks posed by online intermediaries in terms of you know, the addictive qualities giving rise to the heightened risk of self-harm and suicide. That is one of the issues that the legislation is seeking to address, particularly so far as children are concerned. I mean, that's one of the key targets of the legislation, is that all online intermediaries that are used by children, in effect, have to put in place measures to reduce the risk that children will be exposed to content that is likely to encourage them to self-harm or to commit suicide. So, that is a definite target of this legislation. But I should also point out, and I need to be very careful what I say about this, for reasons I won't get into, we also have data protection laws in this jurisdiction, and it's right to say that attempts have been and are being made to use that legislation to curtail the very sorts of harms that you are both talking about. So there's a question about whether, even quite aside from online safety, there are some useful tools available to regulators and indeed claimant firms that want to bring online intermediaries to heel to address the harms that you're raising. And I won't get into some of the current cases, but for example, I was acting for TikTok in a representative class action case that was brought against it, purportedly on behalf of 3.5 million children, whom the claimant was saying had all been harmed by TikTok's processing of their data on the TikTok platform, including because the platform was designed in effect to ensure that children remained addicted to TikTok content. That action was withdrawn for reasons we can go on to talk about, but it just sort of illustrates that people are trying to use existing laws, including data protection laws, to address the harms that you're talking about. And also, I mean, Ryan, you talked about the US becoming the kind of lightning rod for everyone around the world developing, safety laws. Well, I turn it around and say, actually in the UK, or first of all in the EU, that's already happening. And I think the hope is on the part of all those people who care about online safety, and I am one of those people. I would say my clients are also people who care about online safety. What one's hoping is that actually the US will follow suit and start to recognize the ways in which the UK and the EU are actually developing potentially some pretty effective legal principles to address the harms that you're talking about. I mean, the regimes that we have both in the UK and in the EU have their limits. It's really important everyone's aware of those limits. Not least, the UK regime doesn't do anything to address the scourge of online disinformation, which is perhaps the most significant form of harm that we all face at the moment in this current era in the online world, and that is a significant omission. There are also issues about whether our domestic legislation is, future-proof, given the rate of change, technological change, given that it doesn't explicitly address the risk posed by AI. So there are some big questions around this legislation. That's before we even get into issues such as whether the risk in introducing safety legislation is that you throw the free speech baby out with the bathwater. And that is something that a lot of media practitioners, technology practitioners are really worried about in terms of these new safety laws. And I know that in the US, that has been the thing because of the constitutional protection of free speech rights. In a way, that's been the biggest barrier, hasn't it, to the drive to enacting online intermediary safety laws.
Well, that and the lack of an effective government.
Yeah. Well, we know all about that.
And there's no debate. The regime in the US, in the UK, in the EU, in so far as data protection, data privacy is well beyond the United States, and we'll probably never catch up. But I think it was your position, Ryan, that it's the American lawyer through litigation that causes change, whether corporate behavior or just one-off, Meta, Google, whoever.
Yeah, I think I and my colleagues consider ourselves to be important in the role of filling regulatory gaps where they exist, and they do exist in the United States. I would just say one thing to my counterpart about this idea of protecting free speech and keeping perhaps being cautious about overregulation. This concern about being cautious about overregulation and its impact on free speech. I think we're seeing a lack of regulation perhaps contribute to a locking down of the internet. Many companies find the only way to protect their data is to hide it behind paywalls these days. these days. And I'm actually concerned that if we don't have safety protocols implemented, which protect against the risks while encouraging innovation and free speech, that we're essentially going to decimate the modern day public square. And so, and I think that's largely driven by this Sophie's choice we've been given by big tech, which is either you can give up all of your rights and participate in online life, or you simply don't participate in online life. And I think that I don't think that that is the way that we preserve the modern day public square.
But even in the United States, with the First Amendment, you can't cry fire in a crowded theater. So there is some jurisprudence to regulate speech.
That's right.
I think if we were on a public square in America, you'd see people speaking differently than when they're anonymous and on social media.
No doubt.
So that's obviously one of the tensions that we're going to have to find some middle ground. In the next part of our session, I'd like to talk about data privacy, specifically data misuse. And again, I think there's a difference between the UK and the US. In the UK, data misuse or data privacy has not been the subject of a lot of effective litigation. Isn't that accurate?
I think that's reasonably fair. And obviously, you've got a lot of claimant firms who disagree with you and will say their moment is coming. But I think the environment that's faced by claimant firms looking to bring forward data privacy class actions is pretty vexed for a whole raft of reasons that I'm happy to talk through. I mean, we've had a number of representative actions that people have tried to drive through in the data privacy sphere. Those actions have failed for a number of reasons. They include the TikTok action that I mentioned earlier. They include another action more recently that was brought against Google and DeepMind in connection with its processing of patient data in support of NHS clinical decision-making. We've seen claimant firms struggle to even bring forward, more conservative, less grandiose, opt-in group actions. In a recent case that I've been involved with on behalf of the Police Federation, that would be an illustration of claimant firms struggling even to mount that much more kind of confined, circumscribed type of class action. So I think the environment that claimant firms face is pretty vexed, but that's not to say they're not still trying. I mean, just judged from my own kind of very parochial perspective, the market is still very vibrant. I'm still incredibly busy dealing with endless kind of threats of class actions or class actions coming forward. So, there's still definitely life in the class action dog, but it's a vexed environment. We also obviously have to consider, the other side of the coin, which is the regulatory environment, because, I think from a US perspective, you see class actions as the way of creating, a healthy environment in terms of protection of data privacy rights. I think in the UK, the perspective is, the focus is much more on, well, we've got a regulator with his incredible draconian powers. Why can't they do the job of bringing errant data controllers to heel? That's a really important question, in my view. I mean, if I just give you a nutshell of what's been happening in the regulatory space, we've had the GDPR principles in play now for 5 years. What's happened in those 5 years? We've seen a very small handful of enforcement decisions by the ICO, BA, Marriott, both penalty cases, Experian, which was an enforcement case looking to shut down part of Experian's data analytics business, an enforcement notice and penalty notice imposed on Clearview, a US facial recognition company, and then most recently, a £12.5 million penalty imposed on TikTok, again in connection with the processing of TikTok's processing of children's data on the platform. And I should say, for my sins, have been involved in all of those cases. Well, the ICO has more or less landed flat on its face in every one of those cases. In BA and Marriott, vast fines were threatened to be imposed, only for the ICO ultimately to back down and impose really, pretty trivial fines in all the circumstances. Experian, the ICO substantially lost on appeal. Clearview, the facial recognition case, we've just had judgment in our favour, the tribunal deciding that the ICO had no jurisdiction to issue either the penalty notice or the enforcement notice. And most recently, in respect of the penalty notice issued to TikTok, well, we're also challenging that decision before the tribunal, not least on the basis that the ICO had no jurisdiction to issue the penalty. So what we see is a regulator that means well, that wants to achieve good things for data subjects, but it's just not making the impact. Now you can say, well, that's because it just doesn't have enough money and it's very under-resourced. There is obviously some truth in that. From my perspective, and having been involved in all the lead regulatory cases in this jurisdiction, what I am persistently seeing is very poor decision-making by the ICO. They're going after the wrong targets, and even to the extent that you could say that, well, they might be going after the right targets, they're doing it in very much the wrong way. The quality of their regulatory analysis is very poor and mistargeted, and that's why they keep losing these cases. That's not where we want our regulator to be. We want our regulator to make enforcement effective, impactful decisions, and that is not happening at the moment. As I say, I think obviously because of resourcing considerations, but from my perspective, more because of poor decision-making within the ICO. I think that's something that can and should be addressed. And I personally think, of course, I come at it from my own perspective, having been involved in a lot of these cases, my own personal perspective is far better, as a matter of public policy, that we have an effective regulator that brings in errant controllers to heel, than we look to expand and vivify the UK data privacy class action market. The reason being, I don't see UK data privacy class actions as really serving the interests of data subjects. What I see them doing potentially is very substantially lining the pockets of claimant firms, because they pick the right case, they're going to make an awful lot of money. And what I'm keen to hear about from both John and Ryan, if they're happy to talk about it, is, you know, when you look at the US class actions, what are the final results for data subjects where you win? How much money do they get in their pockets? Because I've heard it mentioned that, in fact, you know, the results for individual data subjects are really trivial. And if that's right, you know, does it really serve the public interest to enable these sorts of actions to come forward? That's a big question as far as I'm concerned.
Well, you want to go ahead and speak to that?
I would, and I know you're going to want to jump in as well, but let me
We have
say...
7 minutes.
Okay.
That's 70.
Let me try to move quickly. I think one of the... we've got a 60-year head start in the United States. I think Adam Polk mentioned it yesterday on stage. So our class action jurisprudence is decades ahead of where you are in the UK and EU. One of the glaring differences to me is that you're really relying on regulators to regulate from a change in behavior perspective, and the class action device here is utilized just for money. In the United States, we always bring a dual objective. And in fact, the primary litigation objective is often a change in behavior. So the lawsuits we filed against the big tech companies, while it seeks restitution to all class members, it also seeks a change in behavior. We want transparency. We want consent. We want to make sure that data is properly procured. It sounds to me like in the UK, you have to rely on the regulator who may be spread thin or under-resourced for those things. So I think that's an important distinction between the two. I do believe that, you know, Dan Gerard gave some comments yesterday about the deterrent effect. I think that having an injunctive component to your class action regime allows for greater deterrence because it can cause a change in behavior. As to the, I'm not surprised that you have the feeling you do about money lining the pockets of claimants and claimants' counsel, because this regime has litigation funders as gatekeepers. We finance all of our own cases in the United States. So we look for the inequities in society. We talk to regular, ordinary people and understand their stories and their experiences as it relates to big, powerful corporations, and we try to be the leveler of the playing field between ordinary people and those big, powerful interests.
Can I just come back on this point about injunctive relief? Because it actually came up in my TikTok, the class action TikTok case I mentioned earlier, where unlike all the other kind of class actions that have come forward in the data privacy space, the claimant was not only seeking damages on behalf of all 3.5 million children, but was also seeking injunctive relief. And we had a very interesting exchange between the judge that was managing that case and the claimant's counsel, where the judge was saying, so you're seeking injunctive relief on behalf of all 3.5 million people. What you're basically seeking, as I understand it, is to have the accounts, the TikTok accounts, of all of those 3.5 million people shut down overnight. He said, I can hear the screaming of 3.5 million children saying, what? I didn't want this to happen. That interferes with my fundamental free speech rights. What on earth do you think you're doing? And the claimant's counsel had absolutely no answer to that question. And I think it's really important, if we come back to the issues of big tech, operation of social platforms, that we also have to think about the role played by fundamental free speech rights, and that we also have to remember that children, as much as adults, enjoy those rights as fundamental rights, as safeguarded under the UN Convention of the Rights of the Child. So the position becomes much more complicated if you're talking about injunctive relief in the context of the management of social media platforms.
See, my response to that would, let me just say this, if I were that lawyer, I would say we don't sell cigarettes or alcohol to children for a reason. Is because they don't have the ability of properly handling something that's substantive.
Yeah, but no child is going to be saying, well, I've got a fundamental right to smoke or to drink. But you will have children and those who represent them saying, this child has a fundamental right to free speech, which has to be respected.
I'll give you another one then. In the United States, children cannot view pornography. Let me say something about damages, because I know that in the US we have a much more vibrant regime. And it's really something still in its juvenile state. So I filed the first privacy class action against DoubleClick in 1999. The internet was not much of a thing. It certainly wasn't the economic engine that it is today. And the one singular claim that took root that we settled that case on was a common law claim, trespass to property. So you have in the 21st century the emergence of 19th and 20th century claims and theories with 21st century technology, and it's not caught up. But I think we're doing a much better job of monetizing privacy, whether it be nominal damages, a concept under Roman law, and I think common law, to the way we look at how information is monetized. I think an economist yesterday said, well, look at dark web prices. And we've done that because that's a market where there's a willing buyer and a willing seller. But also companies in the United States sell this information. There are over 1,000 data brokers in the United States that exist as thriving businesses for profit. And they buy and sell or gather and sell our information. And that has a price. And then you can look at when information is taken in the data privacy or the data breach context, what happens to that individual? They're faced with a present and continuing threat of the loss of their identity. And I've spoken about this before. And we have a product in the United States, any number of them, identity theft protection products. So why isn't a damage figure the cost of that program over the life of that consumer? To your point about nominal damages, there's a project manager for Epic in the room, and what was it? A little bit under $600 per consumer that we distributed in the Capital One data breach that affected 98 million Americans. Now, 98 million Americans didn't choose to receive a benefit, but those that did got that amount of money. So we're still in the development stages of trying to come up with a way of monetizing privacy or property interests. So it remains to be seen where we end up.
And I'll just say as a final thought that I appreciate Anya's point about the TikTok story, and I don't know that one in particular, but I would say that I don't think that there is just this binary choice between free speech and
Sure,
you know,
sure.
regulation. I think we can be more thoughtful. It's hard work, but we can come up with
Well,
nuanced.
that's exactly the balance that the Online Safety Act is seeking to strike, which is why, in addition to these duties of care, these duties to make the online environment safer, the legislation imposes cross-cutting duties to protect free speech, as well as protecting the privacy rights of all individuals. So it's trying to walk that really difficult, delicate line, which has to be walked. I completely agree with you. The question of whether it does that effectively is a question that remains to be answered.
We hope it works.
So I know we're over time. Our time is up. If there are any questions, you know, certainly we would take one, and then the rest of us will be available. Yes, sir.
Thank you for an incredibly, I will say, vivid and rigorous discussion, and I appreciate both sides. Anya, thank you for pushing hard on what's perhaps not a very popular position. The reason I want to ask a question, but pose it in terms of my experiences, we litigated the Facebook Cambridge Analytica action in the United States. We're one of two law firms that got the $725 million result. It's the largest privacy settlement in the United States. And our experience has been that the deterrent effect of private class actions is very important, and that there's a combination and an interplay between the regulators and the class actions mechanism. And as you speak of balance, I think the balance is at the level of the entire system working together. And the regulators have a role, and in fact, in the United States, after 70 years or 60 years of class actions, even the Supreme Court will agree and has stated in its opinions that there's a role for private enforcement. There's a role because it brings up issues from the bottom up, and because it supplements the resources of the federal government. So a little bit with that said, I was wondering if you could comment on that. And you know, I obviously open it to Ryan and John, although I'm kind of throwing a softball at you guys. But anyway, again, thank you for a very interesting panel.
I think a perfect example is the case we have going to trial against Google involving the incognito browser before Judge Gonzalez-Rogers. The state of Texas Attorney General Paxton initiated a companion case on behalf of the state of Texas much later, and certainly after I think we had gotten class certification. So, you know, there's discussion, I'll put it that way, between the Attorney General in Texas and what we're doing in our Google litigation. Of course, we have two cases. The Rodriguez case dealing with the way in which information is harvested from Android phones. So I think there is a hand-in-glove arrangement or relationship more now than ever. For instance, the FTC, the Federal Trade Commission, was deprived by the Supreme Court a couple years ago of the ability of getting money for consumers. They can impose fines, but they can't get money back. So I have got several cases now where I'm cooperating with the FTC, and they're my biggest cheerleader. Because while it may not be a two-way street in terms of information, I can flow a lot back to them, and they're willing to support, in some respects, very respectful, my litigation position, because they know that I have the same interest that they have, getting money back for consumers as well as changing the behavior of that company that we're suing.
Yeah, I agree, and I appreciate the question. We've recently filed cases against several American insurance companies for systematically and en masse denying insurance claims of their insureds using AI technology, which was intended to make their businesses more efficient. It turns out that they use that to shortchange what their insureds are entitled to in terms of coverage. And I suspect that we'll continue to get positive support from insurance commissioners around the country because we are fulfilling an important role of private enforcement when it comes to making sure people who are injured, elderly, senior citizens, obtain the health care that they need.
Well, thank you for the pleasure of your time. Let me thank Anya and Ryan for a very spirited debate. Very informative. Thank you.
Pleasure.